May please, your lordship. Lordship, I am praying for listing of this criminal appeal, lordship.
Listing of
Criminal appeal, lordship.
in what column?
Orders following.
Okay.
Your Lordship, I beg to mention item number 10. My senior is out of station, so may I
10.
please, Your Lordship?
10.
Order.
Item 10.
Yes, sir.
Okay, we wait. We'll see orders only.
My lord.
Hmm.
Obliged.
Daily list for execution item number 1.
Police station. Morigaon Police Station, case number 345/2023, FOXO case number Silo.
Obliged. Item number 3 for orders.
May I please, Your Lordship? Lordship, in this matter, I am appearing as a legal aid counsel. From the office note dated 29/7/24, it appears that neither the AD card nor answer notice has been received back by the registry.
302. Okay. Heard Mr. E. Chaudhary, Learned Legal Aid Counsel for the appellant, and Mr. K.K. Das, Learned Additional Public Prosecutor for the respondent number 1, State of Assam. Post of as per office note dated 29/7/2024, neither AD card nor answer notice has been received back from the respondent number 2. Post of the notice to the respondent number 2 was sent by registered post with AD on 18/5/2020. Post of the case is placed before the Loajima Court to ascertain about the service of notice upon the respondent number 2 and to place a report before the court leaves the case after 2 weeks.
Lordship, LCR has been received, Lordship. Paperwork is to be.
Let this come, then
5.
May please, your lordship.
admit 302 call for LCR. Hired MSS Katonia Learned Legal Aid Counsel
Yes, your.
for the appellant and MSB Bhuyan Learned Addition Senior Counsel and Additional Public Prosecutor assisted by MSM Chakraborty Learned Counsel for the respondent state. Post of the records from the trial court have been received. Post of the registry to take steps for preparation of the paper book, release the case after 4 weeks.
Item number 6.
May I please, Your Lordship? I am appearing as an amicus curiae in the matter, Lordship. While office note dated 3/5/2024, records has been received, Lordship.
U. Chaudhary, Learned Legal Counsel,
Amicus curiae.
amicus curiae for the apple and we, yeah. Baki hini agor to repeat for you.
Obliged.
Item 7 and 8.
My pleasure, Lordship. I am appearing item number 7, Lordship. Their interrogatory application.
Lordship, before my learned friend starts, I have gone through the LCR. Some of them are in vernacular, my lord. For
So, Lordship,
consideration,
we have prepared one compilation, Lordship, and translated it. I will provide it.
May they be taken up on Friday?
Not Friday, already fixed many matters. Maybe next week, Wednesday. Wednesday is okay, 14th. At best, we can do that.
Lordship, their
You furnish then,
Lordship, I will.
and furnish us
Lordship,
also
Lordship,
today, so
Lordship.
that it can be kept.
Lordship.
Okay. Heard Mr. A. Ahmed, Learned Counsel for the appellate in appellant in IA Criminal 397/2023 and MS B. Bhuiyan, learned senior counsel and additional public prosecutor for the opposite party number 1, state of Assam. Mr. Ahmed, learned counsel has submitted that he has prepared a compilation of the evidence of the
Yes.
prosecution witnesses,
Lordship.
including their translated copies.
Lordship.
First off. And has placed 2 copies of the same before the court. First off. The copies raised by Mr. Ahmed be kept with the case record. First of MS Bhuiyan, learned additional public prosecutor, has also been furnished a copy by Mr. Ahmed today.
Lordship, they have already,
Today. First of,
already given.
as, yes, I have already recorded. As sought for by Ms. Bhuiyan, learned additional public prosecutor, lays the case on Wednesday. That is 14.
14. Obliged.
Item number 8 also similar.
Item number 9.
May it please your lordship, this is an interlocutory application under section 5 of Limitation Act for
Hmm.
condonation of delay.
Yes, madam,
Lordship,
madam number 1 and madam number 2.
IA under section 5, Limitation Act,
limitation, how many days delay?
43 days delay.
Lordship, I leave it to. Lordship.
Okay, you have no objection. And yes, okay. Heard Mr.
Y Kothari.
Y. Kothari, learned counsel for the applicant. MS
K. Sharma, Western
K. Sharma, learned counsel for the opposite party number 1. You are the informant. She is the informant.
No, she's the accused.
Sorry.
She's the accused who has been acquitted. I am the
Okay.
informant.
Opposite party number 1. And MS B. Bhuiyan, learned senior counsel and additional public prosecutor, assisted by MS M. Chakraborty, learned counsel for the opposite party number 2, state of Assam. First of the instant application under section 5 of the Limitation Act 1963 is preferred seeking condonation of delay of
43 days, lordship.
40 days. It is here
43.
40 days.
Office.
40 days.
Lordship, 43 days.
It has been corrected here,
Office is
40 days, comma, which is stated to have occurred in filing the accompanying criminal appeal under the proviso to section 372 of the Code of Criminal Procedure 1973. First of para, the applicant as the appellant has preferred the accompanying appeal against a judgment dated 17/5/2023 passed by the learned sessions Judge Dibrugarh in sessions case number 258 of 2014, whereby the Learned Sessions Court acquitted the opposite party number 1 who faced the trial therein, comma, from the charges framed under section 302, Indian Penal Code and section read with section 120B, IPC. Full stop. Para. We have gone through the statements and averments made in the instant application, more particularly, paragraph 3 thereof, wherein the applicant has explained the reasons for which the appeal could not be preferred within the period of statutory period of limitation. Full stop. Having gone through the same we are satisfied. We have the considered view that the applicant has been able to show reasons showing sufficient cause as to why the appeal had to be preferred. "40 days beyond the period of limitation." Post-op. MS so-and-so, Learned Counsel for the opposite party number 1, and MS Priya, Learned Additional Public Prosecutor for the opposite party number 2 state, have submitted, in unison, that they have no objection if the period of delay is condoned and the accompanying appeal is heard on merits. Full stop. We, in view of, as the applicant has shown sufficient cause for the period of delay and the opposite parties have no objection to condone the delay, the instant interlocutory application, seeking condonation of 40 days in preferring the accompanying appeal is allowed. The registry to register the accompanying appeal and thereafter to list the same for admission.
I'll stop that.
To us also.
Okay.
Item number 10,
You find it?
Lord, deeply obliged.
BSL for paper book লাগিব? নহয় জানো? Paper book লাগিব? Paper book মানে LC আহিলে নাই? আহিলে. Yes, your name please.
A Burman. or
A Burman.
on
Heard
behalf of-
Mr. A Burman, Learned Counsel,
On behalf
for,
of
for appearing on behalf of Mr. N.B. Chaudhary, Learned Amicus Curiae for the appellant, and Mr. K.K. Das, Learned Additional Public Prosecutor for the respondent state. Full stop. Office note dated 22/7/2024 has reported that the case records from the case records of sessions case number 135 of 2021 have been received from the Learned Trial Court. Post of registry, the registry to take steps for preparation of the paper book.
My lord, I am serving the sentence in Jorhat jail since last
Lordship,
200.
But you did not take,
Our service.
you
As
did not
regards
take
case.
steps. Why you are not complying? You may be a legal counsel, but you are not complying with the order of the court.
My lord, today only it has been listed.
No, office note dated 26/7/2024. No
How much
dates.
years of practice you have put in?
My lord,
How much years of practice you have put in?
20 years, my lord.
So you don't go through the office notes
I
and you
apologize, my
don't go
lord.
through the orders, past earlier orders.
I apologize, my lord, we will comply with it today.
First complete the
Okay.
formalities
Yes, my lord.
before starting submission on merits.
Yes, my lord.
Third, MS Mehti, learned counsel for the accused appellant. Your legal aid counsel,
Yes, my lord.
learned legal aid counsel for the appellant and MSB wing, learned senior counsel and additional public prosecutor assisted by MS M. Chakraborty, learned counsel for the respondent number 1, State of Assam. Poster MS Mehti, learned legal aid counsel has sought for and is granted 3 days time to take steps
Appeal died.
for service of notice upon the respondent number 2, in deference to the earlier order dated, previous order dated 24/6/2024. So release the case after 4 weeks.
Oblige.
Item number 13.
On 302 and imprisonment for life, Lordship. And the entire,
302.
yes, and the case is based on circumstantial evidence, Lordship. And FIR was lodged by the mother of the accused, alleging that there was a quarrel with his father and suddenly he took up one wooden bottom and thereafter hit on the head of his deceased. Lordship. And incident occurred on 24/9/2013 at about 12:30 a.m.
Midnight.
midnight. And from the evidence I find, Lordship, that people came to know about the incident in the morning. And FIR was lodged on 25/9/2013 at 10:50 a.m. Dear Lordship, why I'm pointing out the dates, because the explanation given by the accused, that also that the delay is some relevancy, has some relevancy. Lordship. Now, FIR, your Lordship will find that,
Hardly how much?
Lordship,
10 hours. Hardly 10 hours.
Lordship, it is written as 25. So it will probably next day.
No.
It is,
24/9.
yes,
Something is wrong. Let us see the affair first.
Lordship. Page 4, I have the translated copy also. Yeah, probably.
Translated. Some original to some. (24/9/1230).
Lordship. I have also said
12:30,
about
12:30, 24/9. Okay. G. You mean to say a whole 24/9/2013. There, FIR was not lodged.
and even IO also says that initially he started investigation on the basis of GD&Q. And seizure was also made, accused was also arrested. Subsequently, he
It
received.
can be done.
That is there.
So Kuntola. The Rati, other one. So you want to say that it happened in the night intervening 23/9/2013 and 24/9/2013. Night intervening
Lordship.
23/9/2013 and 24/9/2013
What it appears from the record. Lordship.
as per the FIR.
FIR, Lordship.
So the entire day of 24/9/2013, the FIR was not
No.
lodged. On the
This is a-
next day, it was
Yes.
lost.
And FIR scribe is Lordship may kindly see page 5. Konoj Bhattacharya, your Lordship will find that
Mhm.
25/9/2013. Here, why I am pointing out because the
Which one you are pointing out?
page 5.
Yes.
It was FIR was written by Lordship that Sri Konoj Bhattacharya.
What
He was not examined here. And the informant also not examined. So contents of the FIR was not proved. That is my submission. FIR may be exhibited by the OC or IO Lordship, but the contents that has to be proved. That is not proved.
But see the SARS.
But that I understand.
See the SARS.
That I understand.
Huh?
That I understand.
That is the night intervening 24 and 25.
Because Lordship, if your Lordship.
If
see
we
the-
go by that, then there is no delay in FIR.
Lordship.
Which one is correct?
And apart from this, Lordship, there is no material to connect the appellant with the crime.
No,
So therefore-
firstly, we have to find out which is the correct position.
And even in fact, if your Lordship.
If we go, I have not read the testimonies,
Lordship.
but what is the position? What is the picture emerges? Whether this is something aberration or material.
It is material Lordship, because Lordship, the.
What is the text and tenor of the evidence of the prosecution witness?
Prosecution evidence is Lordship that they heard about that there the accusers killed. All are hearsay witness. And only a piece of evidence is this FIR Lordship. And that too Lordship, the informant was not examined because of her mental illness Lordship. And the explanation given by the accused is that on the night, on the alleged night Lordship, there was a quarrel with her mother Lordship.
No, I am Mr. Hamid. I'm just asking you. If we read the whole, if you have read the evidence in whole,
Lordship.
from reading the evidence in whole, what is the picture emerges? It is really after 1 day's delay or 10 hours delay? I'm asking that. You have read the entire
Yeah,
evidence?
probably Lordship, it would be 25/9/13. Intervening night of 24 to 25.
Because some
Yes.
many people misunderstand.
Lordship.
That is why I'm asking.
Lordship.
You have to read the whole evidence and what is the,
Lordship.
if something you have,
Lordship.
you are a amicus,
Lordship.
friend of the court.
Lordship.
You have to be fair to the court.
Lordship. Lordship.
And you have to reading the whole evidence.
Lordship.
You have to say that it's actually it was after 10 hours or after 1 day,
Lordship.
more than
That is why I have pointed.
34 hours or 10 hours.
Lordship. That is why I have pointed out that in the morning that people came to know.
So I think it is 10 hours,
Yes,
not
from that
34
statement it
hours,
appears,
perhaps,
Lordship.
because of the charge also.
Lordship.
Somebody might misunderstand that 12:30, what will be the day?
Lordship.
That is why, if you read the whole evidence,
It may-
what
it may-
what is the picture emerges?
that-
10 hours perhaps.
Perhaps.
Night intervening, the charge is perhaps is correct.
Lordship.
Okay, let us read
Because-
the
Look.
evidence.
PW1, your Lordship will find page 9.
Yes.
I know the informant. Accused is the son of informant. The occurrence took place about 4 years back. On the day of occurrence at night about 1 AM, some villagers informed me over mobile that the accused killed his father, Sopu Suren. The occurrence took place at about 12:30 AM. When I heard that the deceased was already expired, I went to the PO at morning. So that is why I was wondering that subsequently on morning they came to know. At PO, I saw the dead body of the deceased at courtyard lying on the floor over a bed sheet. At PO, the villagers told me that the accused killed his father with a wooden batam. Thereafter, I informed the matter to VDP secretary. The VDP secretary informed the matter to the police. Later, police came to the PO and seized the wooden batam in front of me and prepared a seizure list. And I put signature in the seizure list as a witness. Exhibit 1 is the seizure list and Exhibit 1 is my signature. I took the dead body of the deceased to Thana. Police sent the dead body for postmortem. The informant at present is, is a paralyzed patient and she is not able to walk and talk. Cross. I do not remember the name of the informant who called me at night. At PO, the mother of the accused told me about the incident. The name of the VDP secretary is Dhan Bahadur Lama. I went to the PO at about 4:30 to 5 AM and the police arrived there around 7 AM. I do not know whether the police was informed during the night hours. I was not aware about the fact that there was any enmity between the accused and the deceased. Police seized one wooden batam from PO. The quarrel took place at the courtyard of the house. Now PW2. He is the elder brother of deceased. I know the informant. Accused is the son of informant. I also know the deceased person. I do not remember the date of occurrence. On the next morning of the occurrence, I heard from the villagers at night at about 12. There was a quarrel between the father, deceased Soku Suren, and the son accused Bhaiti Suren, and also heard from the villagers that the accused hit his father on head with a wooden baton, and immediately the deceased expired. I went to the PO at morning and found the dead body of the deceased lying on the courtyard of the house. I also heard from the villagers that the accused killed his deceased father with a wooden baton. Police came to the PO at about 6 AM and brought the dead body at Thana. I also went to the Thana with the dead body. Police sent the dead body for postmortem at Difu. I also went to the Difu Civil Hospital. Gross. Deceased was my own younger brother. The deceased used to raise quarrel in the house after being drunk almost daily. Both the deceased and the accused were the cultivators by profession and used to plow their own plot of land. The deceased used to beat both his wife and the accused after being drunk. My house is situated around 10 feet away from the place of occurrence. On the night of occurrence, I was sleeping in my house and so I did not hear any shouting. I went to place of occurrence immediately after the arrival of police. The police recovered a wooden piece of batam, which was 4 feet in height, 3 inches in breadth, approximately, and half inch in thickness, which was in 2 pieces. Accused prior to the occurrence never quarreled with his deceased father. Before the day of the occurrence, I had not heard any quarrel between the accused and the father. I have seen the dead body of the injury was caused on the right side of the forehead. PW3 is the VDP secretary. I know the informant. I have recognized the accused. I also knew the deceased. The incident took place in the year 2013. At the time of incident, I was secretary of VDP. In the following morning of the day of occurrence, some youths of the village came to me and informed me about the death of Soku Suren. Then I went to the house of the deceased. Reaching the veranda of the deceased house, I saw that the deceased was lying in a pool of blood on the ground. Then the villagers who were present there informed me that the son of the deceased, that is accused Bhaiti Suren, had killed the deceased by assaulting him with a wooden baton. I immediately informed the matter to Bukajan police station over phone. Thereafter, the police came to the place of occurrence. The police held an inquest on the dead body, and I put my signature in the inquest report as a witness. Exhibit 2 is the inquest report and Exhibit 2-1 is my signature. From the place of occurrence, the police seized a wooden baton which was used in the incident, and I put my signature in the seizure list. Seizure list Exhibit 1, seizure list Exhibit 1, 2 is my signature. Cross. The police obtained my signature at the time of holding the inquest, and when they seized one wooden baton, the distance from my house to the house of deceased is about 800 meters. I do not know whether there had been any quarrel between the deceased and the accused from before. I saw a pool of blood near the dead body. The seized baton was about 3 to 4 feet long, about 3 inches wide, and about 3 inches thick. I did not witness the incident. PW4. I know the informant. I have recognized the accused. I also knew the deceased. The incident took place in the year 2013. At the time of incident, I was the vice president of VDP. In the following morning of the day of occurrence, some villagers informed me that the deceased Soku Suren had been killed by his son, that is the accused. On receipt of the information, I went to the house of the accused and saw that the dead body of the deceased was lying on the ground near the veranda. At that time, I saw that blood was oozing out of the head of deceased. The people present at the place of occurrence at that time informed me that accused Vaiti Suren had killed his father by dealing blow on the head of his father with a wooden baton. At that time, PW3 was also present at the place of occurrence. The police came to the place of occurrence and held the inquest on the dead body, and I put my signature in the inquest report. Exhibit 2 is the inquest report and Exhibit 2-2 is my signature. Cross. I do not remember the villager who informed me about the incident. I saw that blood was oozing out from the head of the deceased, but I do not know as to which portion of the head the blood was oozing from. There are houses of other persons nearby the house of deceased. Among those houses, the house of Sapna Suren and Nandalal Suren are there. I do not know whether there had been any quarrel between the deceased and the accused from before. I saw the baton at the place of occurrence, and the baton was about 1 to 1.5 inch in wide and about 1 meter in length. The police asked me to put my signature in the inquest report, and I put my signature there. On PW 5 is the doctor who conducted postmortem report, page 17. On 25/9/2013, I was attached to Difu Civil Hospital as medical and health officer. On that day, I conducted postmortem of the deceased Sopur Suren, brought by UBC so-and-so. Reference to PS case number 131 of 13 and found following. External appearance. PM is done on a male dead body of about 55 years age, average build, height so-and-so, complexion so-and-so, short, wearing happened with multiple lacerated wounds on right side of forehead and on right ear with fracture of frontal bone with bleeding. Scalp, multiple lacerated wounds on right side of the forehead and on right ear with fracture on the frontal bone with bleeding.
Medical. Yes.
Membrane is torn and hemorrhage inside frontal bone. Chest, abdomen, no abnormalities, thorax or no abnormalities. In my opinion, cause of death is due to head injury caused by blunt trauma. So here just I'm pointing out one thing, Lordship, that the injuries sustained by the deceased were on right side, Lordship. And it was put a specific question to the IO whether the accused was right-handed or left-handed. It was said that he is right-handed. Because the case is based on circumstantial evidence, therefore I am pointing out it. And in cross part, he said, Lordship,
Hmm.
blunt trauma sustained by the deceased could be due to fall on hard substance or hit against the hard substance. I have not mentioned the size of wounds in Exhibit 3.
Yes. We'll come back.
Lordship.
Any idea?
No, probably it is Lordship that impact. And even learned session judge also given that meaning, Lordship, at paragraph 29 of its judgment, of the judgment, Lordship. That means the disease must be fallen on the hard substance or hit
Page?
page 50 of the paper book, Lordship.
Page 50.
Paragraph 29.
The explanation, there is nothing regarding multiple lacerated wound on forehead and right ear. How to ignore those?
But if you look.
So for lacerated, multiple lacerated wound.
But if your lordship, when you turn to page 31 of the paper book, question number 18 and 19, lordship.
31.
One.
Question number 18, yes.
My deceased father always used to fight with my mother. On the day of the incident at night around 10:30 p.m., my father was intoxicated and was fighting with my mother. Then I asked him not to fight. Then he chased me with a wooden baton measuring 1 inch height and 5 feet long. Then I fled away from there. After about 1 hour, I came back and saw my father was lying on earth and mother was standing nearby. My mother asked me to lift my father. Then I lifted him and saw injuries on his head and blood was oozing out. Then we were sitting near the father of that night. Next morning, my mother informed the matter to the neighboring and people from the neighboring came. Then my mother lost the case against me. Now question number 19. Do you want to adduce evidence? Answer. No, as my mother is suffering from paralysis and could not talk since last 4 years.
4 years.
So she was therefore her examination was required, but
But
as she was
because of her
paralyzed.
inability later on, otherwise it appears it was in
Yes.
2013.
Yes, lordship.
The incident happened
Lordship.
and evidence started in 2019,
Lordship,
18,
Lordship,
18, after 5 years.
yes. Page
Evidence
four-
started after 5 years.
Yes. Page
Let us see the
47
SAR sheet.
Lordship, may I say page
SAR
47?
sheet, where is the SAR sheet?
Was a weakness.
She was a listed
You are
witness.
listed witness. No,
There is
there is
a
a,
order
there is a
of
order of the
2024.
cry. code.
13/12/2019.
13, 12.
2009, I had marked it, my lord, orange color flag.
That operation is, your lordship will find page 47 of the paper book, paragraph 22 of the judgment.
Paragraph 22. Page
47.
This Main Street. Is there to sound? Is there to sound?
The statement is there. madam.
So what will be the effect? Our testimony is not recorded now because of that. And other witnesses, say for example, is PW1, PW2, PW3, PW4. They came in the morning to the place of occurrence and heard from villagers that disease was killed by the accused. And those kind of testimony is hearsay. Yes, they have seen the body
Yes.
with head injury
Your Lordship.
at the place of occurrence. That much is acceptable. PW1 to PW4.
Four.
That much is acceptable. Now, PW5,
Doctor.
there are two things. One is that death is due to head injury caused by blunt trauma. That is one. And secondly, multiple lacerated wounds. Right? Now, so far blunt trauma is concerned, blunt trauma, as per medical terminology, refers to English normal injury of the body by forceful impact with a dull object. So, with blind force trauma, there can be internal organ injuries that are not immediately visible. But lacerated on multiple, one or two, three, okay. But this cannot be taken into account. 161 statement.
161, in fact, he admitted.
161 of the mother cannot be
161 of the mother, my lord.
cannot be taken.
And your lordship, although it goes against the prosecution, she was paralytic, she was unable to speak. Then how come she gave that evidence? It hasn't come up on evidence.
No. We counted. Accused himself says
My lord,
since 4 years,
lordship,
paralysis and
she cannot speak.
can't speak. Incident happened in 2013.
Okay.
Examination of witnesses started in 2018.
Then
It
after the
continued in
incident- Yes, yes.
2019.
Yes, ma'am.
So, at that time, she was hale and hardy.
Yes, at the time of occurrence of in 2013.
But in course of time, she became paralytic.
Lordship, but one factor, my lord,
Mm.
his presence, apart from one of the witness, my lord, that he had quarrel, my lord. One of the neighbors have
No,
reported.
he used to hear quarrel.
No, they had
Which
a
one?
good relation.
They have good relation. Elder brother of the disease himself says that it was the disease who used to disturb
Yeah, disease is to-
after
yes,
being drunk.
yes,
And he used to harass
lordship,
his wife and his son.
my lord.
But he said nothing adverse against the
Accused
accused.
appellant, and his presence, except the IO, he said he was arrested from the place of occurrence. He was there.
But he has provided an explanation.
Yes, your lordship.
He has provided.
No, but explanation
And
provided.
there is motive does not come out.
No,
Motive, yes, harassment is there.
may kindly have a look, page 31.
There is a gap of 1 hour
Gap of
as
1
per
hour,
his
but he doesn't
explanation,
say that
right?
He doesn't say he has caused injury. But there's a gap, my lord.
1
I-
hour.
My deceased father always used to fight with my mother. On the day of the incident at night at around 10:30 p.m., my father was intoxicated and was fighting with my mother. Then I asked him not to fight. Then he chased me with a wooden bottom measuring 1 inch height and 5 feet long. Then I fled away from there. After about 1 hour, I
Mm.
came back and saw my father was lying on earth and mother was standing nearby.
Mm.
My mother asked me to lift my father. Then I lifted him and saw injuries on his head and blood was oozing out. Then we were sitting near the father on that night. Next morning, my mother informed the matter to the neighborhood, and the people from the neighborhood came there. Then my mother lost the case against him.
That mother lost the case.
Yes.
That is against him. And plus
Yes.
1 hour,
Lordship.
he went out and came back. Then his PW2 elder brother of the deceased. He did not hear anything on that day,
I know.
and he said adversely against the deceased,
I know.
not against the accused. In fact, he certified the accused prior to the occurrence never quarreled with his deceased father. He certified
Lordship.
about the accused. The whole issue is because mother did not depose, though. But the prosecution has established.
Lordship, I think he owes an explanation, but his presence at the place of occurrence.
Because this head injury, opinion is head injury caused by blunt trauma. And blunt trauma does not specifically refer to
Bottom.
Batam or whatever. It was not shown to the doctor also
Yes.
that yes, it is possible by this kind of Batam wooden thing to cause blunt trauma, head injury leading to blunt trauma. Because otherwise blunt trauma can also happen forceful impact with a dull object. Now the trial court has said that it was grassy land, all this body was found in grassy land. These are all imagination.
Imagination. Lordship.
Batam, which was seized, Lordship, that was not sent for FSL and no bulletin was found in that Batam. In the seizure list, no mention.
No
about-
bloodstain also.
Yes, the seizure list.
To connect that wooden Batam with the murder also, that disease was bleeding
Hello.
from head injury. And Batam, nobody says it was bloodstained.
That seizure list will be Lordship will be on page
Let us see
57.
the seizure list.
Page
Page
57.
57.
No mention about blood stain. Lordship.
No mention about bloodstain.
Page.
Page
57.
57.
Cannot be, it has to be legal conviction.
Ship. And my learned friend is informed, just informed, he is there, he is behind the bus since 2030, you know, from date of judgment.
Earlier he was there.
From the date of judgment, yes,
Date of judgment.
2020. Oh, no, not 2020.
When this, let us see the commitment order.
Commitment,
Page
page
8.
8.
During committal also he was in custody.
Hmm?
Page 8.
From custody,
Yes.
and during trial,
Subsequently he was released on bail.
release and bail. Yes, harassment to the mother, harassment to him. But whether that could be uh, termed as motive.
Cannot be.
Hmm.
May come under the exception, but your lordship, presence, I don't think.
Because of the absence of the mother, it becomes a case of circumstantial evidence. And whether it is a homicidal death, that is also not said by doctor. Not said by doctor in clear terms. Head injury due to blind trauma. And possibility of blind trauma can be either somebody giving a blow or impact, forceful impact on a hard
Hard
object.
substance.
It is not said that the head injury is sufficient in the ordinary course of nature to cause it. It is also not there. Homicidal death, opinion is not there.
Under 106, I think accused ditches his burden.
He has given a plausible, at least an explanation.
No.
But that comes after prosecution
Yes.
establishes the links by credible evidence. Now, as soon as one eyewitness would have been
Enough.
enough, mother, she did not depose. Then her 161 statement cannot be made use of.
Yes, in absence of the
We cannot pick up that
lordship.
there is a bar. She did not die also. Otherwise, that also would not be a dying declaration.
Lordship.
Even if she died, her previous statement.
Can this matter be sent back now? No.
What at this stage? What? How? She is paralytic. What evidence you will collect by additional evidence? She is not in a position to talk.
No, that time in 2021, it was like in 2019, she was paralytic. 2021, he deposed, right? 21, 22?
21.
21. So by 3 years have elapsed.
Paralysis, and these are not persons who will be treated in Apollo or Max or Bombay.
Fine.
That paralysis will be reversed, speechlessness will be reversed. These are, I think,
Poor village.
tea garden community people, perhaps,
Cultivators.
cultivator. Staying in Karbi Anglong Diffu, maybe interior place. That possibility is not there. Orial Dubi Mazgaon, police station, Bokajan, scheduled tribe,
That is the
daily
border,
wage earner.
that is the borderline of Gulaghat and Karbi.
That possibility is not there.
Lordship.
Okay. लिखो करो Start. Hilltop Solar, North Stone, Traveler, Hotel, Stick, then Stick.
Lordship, if your lordship considers the inquest report approximate time of date is 12:30.
Hmm,
So from Trivantri's statement, 10:30 PM he went out, your lordship. 11:30 he came back.
hmm.
Then date of occurrence, time of occurrence is 12:30.
This will be inference. Accused's previous conduct was not bad.
Not bad. And his subsequent conduct is
Subsequent
also good. He was there at the time of
Ah.
the place of occurrence.
At the
When the
place of
police
occurrence.
arrived.
You can start. 1 minute. Oh,
Another judgment has arrived under 106, latest one,
106.
but it goes against us.
It is. In a case based on circumstantial evidence, find out motive is important and
Yes, sir,
motive.
that is
right?
motive 1992.
Huh? Give one.
Uh,
And secondly,
19.
medical doctor that wooden
Okay,
stick or batam was not exhibited,
Lordship,
right?
Lordship.
And from the seizure list, there was no blood stain.
Lordship.
And medical doctor was not shown the wooden stick to at least have an opinion that injury that was sustained by the disease could be caused by such an wooden baton. And motive was not there. Disease conduct was, he was always the aggressor. Accused previous conduct was not there.
Yeah, I have given 3 citations, Lordship, that yes, if I may please, Lordship, that regarding that weapon, Lordship, that also not sent, that is also
Hmm.
there, Lordship.
Ms. Bhuyan, this is paragraph 7.
Two 2017-14 SCC, Lordship. Seventeen, 14, 359, Anjan Kumar Sharma versus State of Assam.
Paragraph.
Paragraph 14 and 16, Lordship. On paragraph 18 regarding that blood stain, Lordship, may I kindly say?
Mhm.
Paragraph 18.
Yes, next
Next, Lordship, 2016-10 SCC 298.
paragraph.
Paragraph, Lordship, 25, 26, and 27. The judgment authored by Honorable Mr. Justice Amitabh Roy.
And 2016-14 SSC.
That is paragraph 20, that is on benefit of doubt, Lordship. And in paragraph 26, that Sarath Bijichan is quoted.
Then we'll start at 2.
Okay. And only, I'm sorry that I will give the after a break, Lordship, that one citation regarding motive, Lordship, that 1992 to SCC 153, Lordship, that I will give after a break.
Okay, we'll resume at 2.
Lordship. On motive part, Lordship, that judgment I have given. Paragraph 9, Lordship. Paragraph 9.
If take a seat.
I'm sorry to say, Lordship, if I may leave for a moment, my junior will be here, Lordship. I will come back.
This criminal appeal. From jail under section 383, Code of Criminal Procedure 1983. The code or CRPC for short is directed against a judgment and order dated 21/12/2021 passed by the Court of Learned Sessions Judge Karvi Anglong at Difu in New Sessions Case number 18 of 2018 within bracket old sessions, case number 40 of 2014, bracket close, comma, which arose out of Bokajan Police Station, case number 131 of 2013 and ZR case number 729 of 2013. Posted. In the trial of comma, the accused appellant faced a charge of patricide. And after the trial, comma, the learned session judge finding him guilty for committing the murder of his father. Comma, Sukhu Soren, Sukhu, Sukhu Soren. Under section 302, 300 APC, comma, has sentenced the accused appellant to undergo imprisonment for life and to pay a fine of rupees 5,000, in default of payment of fine, to undergo rigorous imprisonment for another year. Full stop. We have heard Mr. A. Ahmed, learned amicus curiae for the accused appellant, and MSP Bhuiya, learned senior counsel and additional public prosecutor for the respondent state, assisted by MSM Chakraborty, learned counsel. Full stop. Para. Mr. Ahmed, learned counsel appearing for the accused appellant, has submitted, at first, that though at the time of submission of the charge sheet, the prosecution listed the wife, listed Shakuntala Suren, the wife of the deceased and the mother of the accused, as an eyewitness. But in the course of trial, the prosecution did not examine Shakuntala Suren as a witness, as she, in the meantime, had become unable to testify due to her paralytic condition and loss of speech, right? Full stop. As a result, comma, the prosecution sought to prove the charge of patricide against the accused on the basis of circumstantial evidence. Full stop. Mr. Ahmed has submitted that there were many missing links in the prosecution story, and the vital circumstances were not proved by credible evidence. Full stop. He has contended that the medical evidence is deficient to establish that the death of the deceased was a homicidal one. Full stop. He has submitted that most of the witnesses, comma, other than the autopsy doctor and the IO, comma, were witnesses who had reached the place of occurrence much after the alleged incident, which occurred in the night intervening 24/9/2023 to 2013 stroke 25/9/2013. Full stop. Containing as above, comma, Mr. Ahmed has submitted that in view of failure on the part of the prosecution to establish its case, the accused was not required to provide any explanation. Full stop. Yet, comma, the accused had provided an explanation which, comma, according to Mr. Ahmed, comma, was a plausible one. Full stop. But the learned trial court proceeded to draw inferences from various circumstances to reach the finding of guilt against the accused. Full stop. The amicus curiae has thus contended that the in view of the missing links, the benefit should go to the petitioner. Full stop. Para. MS Puya, learned senior counsel and additional public prosecutor appearing for the state, has submitted that the learned trial court, after proper appreciation of the evidence stroke materials on record, has rightly reached the finding as regards guilt of the accused. Pusto. MS Puya has contended that as per the post-mortem examination report, there were multiple lacerated wounds on the forehead and ear of the deceased. And since it has been established that the accused was present in the house in the night intervening 24/9/2020, 2013 and 25/9/2013, he was obliged, he was under obligation to provide a plausible and acceptable explanation as to in what circumstances his father, that is the deceased, met his death on that fateful night. Pusto. Yes, anything?
Inquest report.
Ah.
Suggests that approximate time is 12:30 AM. Is 60.
Inquest report, is there any scientific basis? Inquest is done by some executive magistrate or IO.
Lordship, but time, my lord, you was present there.
Huh?
He was present.
Inquest report, which page?
Page 60.
Page 60.
61 is serial number 7, dead body. Approximate age 55 years. Approximate date and time of date 25/9 at 12:30 AM.
Hey, Eric. এটা cricket মানে type করা আছে, তাতে inquest report দিয়ে আছে, suppose.
Even
Referring to the inquest report,
as well as the PM report also says that.
referring to the inquest report, MS Bhuya has pointed out that the time of death was mentioned as 12:30 AM on 25/9/2013. And similarly,
Sure, I'm sorry. It's not there in the PM report. It's not there. It's date of examination only. 25/9, 12:30 PM.
12:30. And the same is consistent with the version given in the FIR, lodged on 20 5/9/2013 by the wife of the deceased, who is also the mother of the uh, uh, deceased. Stop. Yes, anything more?
Explanation given by the accused person, 10:30, he
In such circumstances, the explanation given by the accused during his examination under section 313 CRPC cannot be accepted. Full stop. MS Bhuiyan has contended that taking into consideration the facts and circumstances of the case, in its entirety, it has clearly emerged that it was the accused who was the perpetrator of the crime. So therefore, the judgment and order of the learned trial court is not to be interfered with. So consequently, the present appeal, female appeal, is not merited.
Lordship, alternative submission can it be recorded? At this stage also, since the matter
But-
could not be examined,
Uh,
the matter be sent back.
MS Bhuiyan has alternatively has also submitted in the alternative that if it is found that the prosecution case has suffered due to non-examination of the informant who was the only possible eyewitness, the matter can be, the case can be remanded back for additional evidence, for recording additional evidence of the informant wife of the deceased Rustam Perao. We have given our consideration to the submissions of the learned counsel for the parties. And I have also perused evidence stroke materials on record, including the testimonies of the prosecution witnesses, and the documentary evidence available in the case records of sections case number 18 of 2018, in original. Poster. We have also gone through the citations referred to by the Learned Council for the parties in support of their submissions. Poster. Para. Before. Consideration of before considering the respective submissions and contentions of the Learned Council for the parties, it appears apposite to exposit on the sequence of events from the stage of registration of the crime case to the submission of the charge sheet against the accused. Full stop. Para. Mhm. It was at about 7:05 a.m. on 25/9/2013, an information was telephonically given at Bokajan Police Station by one Dhon Bahadur Lama that a murder had taken place at village as Horialdubi Mazgaon. Full stop. On receiving such telephonic information, the officer in charge, Bokajan Police Station, made a general diary entry, general diary entry number 691, and asked Biman Kaur, an assistant sub-inspector of police attached to Bokajan Police Station, Biman Kaur, within bracket PW6, to proceed to the place of occurrence. Full stop. A general diary entry number 691 to EXT4 করে দিব। Full stop. Biman Kaur, ASI, who was the investigating officer of the who was also the investigating officer of the case, IO, accordingly proceeded to the place of occurrence, that is the house of the deceased and the accused at village Kodialdubi Matgaon. Pusto PO করে দিব। At the PO, along with staff. At the PO, the IO, PW6, met Khan Bahadur Lama, PW3, who informed the police team about the matter. Full stop. At the PO, the IO found the dead body of the deceased lying on a bamboo mat at a courtyard, and it was found covered with a piece of cloth. Full stop. Thereafter, the officer in charge, Bokajan Police Station. It was thereafter the officer in charge, Bokajan Police Station, entrusted the entrusted Biman for PW6A to do preliminary investigation. Full stop. Accordingly, the IO finding a wooden baten বুলি ইয়া কৈছোন বি বাটামটো অসমীয়াত কয় বাটেন seized it by a seizure list by preparing a seizure list. MR number 85/2013. EXT1 in presence of witnesses. The IO also drew up a sketch map of the PO EXT5 and held inquest on the dead body of the deceased to the subdivisional officer, Civil Bokajan. Post of the subdivisional officer, Civil Bokajan, after completing the inquest proceeding, prepared an inquest report, EXT2, recording his findings therein. Post of. As the accused was found at the place of occurrence, he was interrogated by the IO and thereafter, was taken into custody. Also, the IO also recorded the statements of the witnesses who were available at the place of occurrence at the PO. Poster. After completing the above formalities, the IO forwarded, took the dead body to the police station at first, and thereafter, send the dead body to the Deepu Civil Hospital for post-mortem examination. Post. On 25/9/2013. Poster. The postmortem examination on the dead body of the deceased was performed at Deepu Civil Hospital. On 25/9/2013. By the medical health officer, Dr. Son Kumar Das, SON, Son Kumar Das, PW 5. And after conducting autopsy, PW 5 recorded his findings in an post-mortem examination PME report EXT3. Stop. After collecting the PME report EXT3 and completing the remaining part of the investigation, Command IO of the case PW 6 submitted a charge sheet under section 173 to CRPC, white charge sheet number 67/2013 on 29/11/2013, finding a privacy case well established against the accused for the offense under section 302 IPC. Post para. After submission of the charge sheet, that times there was no separation of judiciary. The magistrate first class Karbi Anglong Difu secured the appearance of the accused who was in custody, after arrest, or who was in custody, from jail, and complied with the procedure laid down in section 207 IPC by furnishing him the copies of the case. Post of, as the offense under section 302, IPC is exclusively triable by the Court of Sessions, the Lion Magistrate First Class Karbi Anglong Difu committed the case records of GR case number 729 of 2013 to the Court of Sessions by an order commitment dated 1/4/2014. Full stop. While notifying the learned public prosecutor, the prosecuting inspector was directed to produce the accused before the Court of Sessions on 4/9/2014. Full stop. Fair. It is relevant to mention that at the relevant time, a sessions tribal, no, a sessions case was tried before at the relevant to mention at the relevant time, a sessions case in the district of Karbi Anglong used to be tried before the Deputy Commissioner, as during that time, the judiciary was not separated from the executive in the district of Karbi Anglong. Full stop. Para. On receipt of the case records of GR case number so and so, the Court of Deputy Commissioner, the any case number? No, it will be a number two. The same was registered. It was like an old case number. As Sessions case number 40 of 2014. So before the Court of Deputy Commissioner, Karbi Anglong, the case was opened by the learned public prosecutor. Full stop. After hearing the learned public prosecutor and the learned defense counsel, a charge under section 302, which was framed against the accused on 6/10/2015. Full stop. The charge was then read over and explained to the accused. When the charge was read over and explained to the accused, the accused pleaded not guilty and claimed to be tried. Full stop. এই আগৰ গ্যাপটোত এইখিনি সোমাব লাগিব ষ্টাৰ কৰি when inquest was done, time
Request page 16.
12:30. Inquest or agot.
Eight AM.
Hmm?
Page 63.
63.
Serial number 15.
And
Date and time of inquest, 25/9, 8 AM.
8 AM to लिखे हुए inquest और नहीं लिखे हुए तो third episode लिखे हुए close on the heels of the inquest proceeding, comma, the first information report came to be lodged at around 10:15 AM by Shakuntala Suren, who was the wife of the deceased and the mother of the accused, before the officer in charge, Bukajan Police Station, Gustav, on receipt of the FIR, comma, the officer in charge registered the same as Bukajan Police Station case number 131 of 2013 under section 302 IPC. And allowed Biman Kaur to continue with the investigation of the case. এইখিনিতে মাজত সোমাই দিব লাগিব। After the stage of framing of charge, comma, the recording of evidence of the prosecution witnesses took place before the Court of Sessions, Karbi Anglong, as in the meantime, comma, the separation between the judiciary and the executive took place in the district of Karbi Anglong. Full stop. On such separation, comma, the case number stood changed from old sessions case number 40 of 2014 to sessions case number 18 of 2018. Full stop. Before the learned Court of Sessions, comma, the prosecution examined seven number of witnesses and exhibited seven number of documents to bring home the charge against the accused. Full stop. The prosecution witnesses who were examined by the prosecution were page 56. And the documents which were exhibited were page 56. Full stop. Fair. After closure of evidence from the prosecution side, the accused was examined under Section 313 CRPC, and he was asked to explain the circumstances by putting before him the incriminating materials emerging from the evidence of the prosecution, evidence laid by the prosecution. Full stop. Apart from taking the plea of denial, the accused had made an explanation, had given an explanation as regards the circumstances under which he found the deceased dead. First, after hearing the learned counsel for the parties and after appreciation of the evidence stock materials on record, the learned session judge has rendered the judgment and order, impugned hearing on finding the accused guilty for the offense of patricide. Full stop. Fair. The learned trial court in the impugned judgment and order had observed that the affair EXT6 was lodged by the wife of the deceased, wherein it was entirely alleged that there was an altercation between the deceased and the accused preceding the date of the deceased. Full stop. The trial court had noted that as the informant was found to be mentally ill at the time of taking evidence, the examination of the informant had to be dispensed with by passing an order on 13/12/2019. Full stop. And it was on such backdrop, the affair EXT6 was proved by the prosecution through the officer in charge, Bukajan Police Station, by examining him as PW7. Full stop. The learned trial court had recorded that except the informant, there was no eyewitness so far as the alleged incident is concerned. Alleged incident and the alleged assault is concerned. And that's, the case of the prosecution rested on circumstantial evidence. Full stop. One of the premise for a London trial court to arrive at a finding of guilt was that the prosecution witnesses had unequivocally deposed that they heard that the accused had killed his deceased father, and the said fact was corroborated by the FIR EXT6 lodged by the informant wife of the deceased. Full stop. The learned trial court had held that from the nature of the injury sustained by the deceased, it can be presumed that the injury cannot be sustained only due to one fall on grassy land and the multiple lacerated wounds found on the person of the deceased indicated towards a fight between the accused deceased and the accused at the time of occurrence. Full stop. Para. We now turn to the testimonies of the prosecution witnesses. That's PW1, PW2, PW3, and PW4. At first, Houston, sub. No, at first, Houston. PW PW1. PW1, no? Who is he?
Was Caesar witness to Uden Batam.
Otherwise,
Otherwise, he hired.
co-villager.
Co-villager.
Hmm?
Co-villager.
The prosecution, prosecution witness, PW1, Diwan Soren is a co-villager. Oh, all the four prosecution witnesses were inhabitants of the village Horial Dubi Majgaon. Full stop. Who are the village defense party?
PW2 is the elder brother of DC.
BDP.
PW 1, Diwan Soren.
Three and
Oh.
four are the VDPs.
নালাগে। Diwan Soren নালাগে। PW2, Aswa Soren is the elder brother of the deceased. Full stop. PW3, Dhanbadur Lama and PW4, Purna Mura were the secretary and vice president of the Village Defense Party, respectively of the Village Defense Party at the relevant point of time. Full stop. Pair. Subpair. In his testimony, PW1 deposed that he was informed by the villagers about the no the evidence deposed that on at about 1 a.m. on the date of the incident, he was informed telephonically by some villagers that the accused killed his father at around 12:30 a.m. that night. When he heard that the disease had already expired, he went to the PO only in the morning hours. Going there, he saw the dead body of the deceased lying in the courtyard. Full stop. At the PO, the villagers told him that the accused killed his father with a wooden baton. Full stop. Thereafter, he informed the matter to the VDP, secretary of the VDP, who in turn, informed the matter to police. Full stop. Thereafter, police personnel came to the PO and seized the wooden baton by preparing a seizure list in his presence. And he, seizure list EXT1 in his presence, and he subscribed, he gave his signature therein as EXT11. Full stop. PW1 stated that the informant was at that time, in a paralytic condition, and she was not in a position to walk, also not in a position to walk and talk. Full stop. In cross-examination, PW1 disclosed the name, stated that Dhanbadur Lama, PW 3, was the secretary of the VDP at that point of time. Full stop. He further stated that he went to the PO in between 4:30 AM and 5 AM. And the police personnel arrived at the PO at around 7 AM. Full stop. As regards the relationship between the accused and the deceased, PW1 deposed to the effect that there was no enmity between the accused and the deceased. Full stop. Para. PW2 Aswa Sarin deposed to the effect that he heard in the morning hours of the date of the incident, he heard from the villagers that at around 12 o'clock night, there was a quarrel between the deceased and the accused. And during the quarrel, the accused had hit his father on his head with a wooden batam, resulting in instantaneous death of the deceased. So, PW2 further stated that he went to the PO in morning and found the dead body of the deceased lying on the courtyard of the house. Full stop. PW2 also stated to have heard from the villagers that the accused killed his deceased father with the wooden baton. Full stop. According to PW2, police personnel arrived at the PO at around 6 AM. And thereafter, the dead body was taken to the police station. During cross-examination, PW2 stated that the deceased was his own younger brother. Full stop. PW2 stated that the deceased used to enter into raise quarrel in the house after being drunk almost daily. Full stop. PW2 further testified that both the deceased and the accused were cultivators and they used to plow their own plots of land. Full stop. PW2 further disclosed that the deceased used to beat both his wife and the accused after being drunk. Full stop. Stating that his house is situated at a distance of 10 feet. PW2 stated that he did not hear any shouting on the night of occurrence. Full stop. PW2 described the dimensions of the wooden batam which he found in two pieces. Full stop. PW to also disclose that the accused, he did not find the accused entering into quarrel with his deceased father prior to the date of occurrence. Also, PW stated to have noticed an injury on the right side of the forehead of the deceased. Para. PW3 Dhanbahadur Lama also arrived at the PO, the Dhanbahadur Lama, the secretary of the VDP, also arrived at the PO only in the morning hours. PW3 stated that at the PO, he saw the dead body of the deceased lying in a pool of blood on the ground. So he was informed by the villagers, present there, that it was the accused who had killed the deceased by assaulting the deceased with a wooden batam. PW3 further stated that he immediately informed the matter to Bukajan police station of Harpur. Pursuant to his information, the police personnel came to the PO and held inquest on the dead body of the deceased. PW3 exhibited the inquest report as EXT2, which is signature therein as EXT21. PW3 further disclosed that the police seized a wooden batam from the PO. Wooden batam, which was used in the incident, from the PO. And he was an witness to the seizure list, EXT1, prepared in that connection, and also exhibited his signature therein as EXT21 during cross-examination, PW3 stated that he had no knowledge whether there was any quarrel, whether there was any quarrel between the accused and the deceased from a prior point of time. PW3 also gave a description of the wooden batam seized by EXT1, while clarifying that he did not witness any incident. Para. PW4, Purnam Mura, who was the vice president of the PDP, also came to the PO only in the morning hours on the date of the incident. In his testimony, PW4 stated that at the PO, he was informed by some villagers that the accused had been killed by his son, that is, the accused. So disease had been killed. And the PO, by going to the PO, he noticed that the dead body was lying on the ground and blood was oozing out of the head of the deceased. Full stop. PW4 acknowledged the presence of PW3 at the PO at that time. Full stop. Like PW3, PW4 was also a witness to the seizure list EXT 2, and he identified his signature therein as EXT 22. Full stop. During cross-examination, PW4 stated that he had no knowledge about any quarrel between the accused, deceased and the accused. Full stop. Like PW4, 3, PW4 also gave a description about the dimensions of the wooden bottom, seized by EXT. One, seizure list. Full stop. Where? On evaluation, on analyzing, upon an analysis of the testimonies of the aforementioned 4 witnesses, it is found that all these witnesses had appeared at the place of occurrence, that is the house of the deceased and the accused, only after the death of the deceased. Full stop. All these witnesses had deposed in a similar manner that at the PO, they were informed by the villagers, some villagers, that the deceased had been killed by the accused by an wooden bottom. Full stop. But none of these prosecution witnesses had named the villagers who had informed them about the manner as to how the deceased had met his death at the hand of the accused. Full stop. Other than these 4 prosecution witnesses, no other villagers were examined by the prosecution. Full stop. In such backdrop, comma, the evidence of these prosecution witnesses that they were informed by some villagers as to how the incident had occurred and as to how the incident took place. Once they arrived at the place of occurrence, is not an evidence, is not a piece of evidence to add weight, add weight to the prosecution case, as such nature of evidence ex facie is hearsay evidence. Full stop. After excluding the above part of the testimonies of this prosecution evidence, we find from the remaining part that remaining parts of these prosecution witnesses that they PW 4 and 5, 4 and PW PW 1 that PW 1 and PW 3 were witnesses to the seizure list EXT1, whereby a wooden bottom was seized from the PO, and PW3 and PW4 were witnesses to the inquest proceeding, whereafter the inquest report EXT3 was prepared. Right? Correct? Post stop.
Inquest report is
Full stop.
exhibit 2.
Huh?
Exhibit 2, inquest report.
EXT?
Exhibit
EXT2, I have
2.
said. Post stop. Para. What has further emerged from the testimony of PW one, PW 2? No. What is from that? What has further emerged from the testimonies of these prosecution witnesses is that these witnesses prior to the date of occurrence, these witnesses, there was no enmity between the deceased and the accused. Full stop. From the evidence of PW2, who was an elder brother of the deceased, it has emerged that the deceased was habituated to drink and after being drunk, almost daily, he used to raise quarrel in his house. And in the process of such quarrels, he used to beat his wife, that is the informant, and the accused. Full stop. PW2 who is a close relative of both the accused and the deceased and the accused. Also testified that from no quarrel from their the accused never used to raise quarrel with his father. First. PW3 and PW4 who, apart from being functionaries of the VDP, were also co-villagers of the deceased and the accused, had corroborated that had deposed that they had no knowledge about existence of any animosity between the deceased and the accused. Full stop. Fair. PW5. No, I'm sorry. And the learned additional public prosecutor. One of the contentions of the learned public prosecutor is that yes, in-case proceeding question.
Time to.
No, time to question, hurry to question. Question. In-case phase 2. What you have pointed out?
Lordship, the time of death as has been
Uh,
prescribed in the inquest report matches with the time.
is that the time of date, approximate time and date of date mentioned in the inquest report matched with the time and date mentioned in time and date of date, approximate date, time and date of date mentioned in the FIR. EXT 2 আৰু FIR 6. It is right to mention that neither a first information report nor a inquest report is considered to be substantive piece of evidence. Full stop. Definitely. The object of an inquest proceeding under section 174 CRPC is merely to ascertain whether a person died under suspicious circumstances or met with an unnatural death. And, if so, what was its apparent cause? The question regarding details of how the disease was assaulted or who assaulted him or under what circumstances he was assaulted is alien, is outside the is alien. No, is outside the ambit and scope of an inquest proceeding. Full stop. On the other hand, a first information report to this is, uh, খবর বিষয় গ্যাস দিচ্ছি একজ্যাক্ট বর্তমান PW 455, no? PW5. Dr. Sunkumar Das, who, on 25/9/2013, serving as medical and health officer at Deepu Civil Hospital, performed a post-mortem examination on the dead body of the deceased, Sukur Soren, who was identified by UBC, Zibon Phukon and Devan Soren. Poster. In his testimony, PW5 stated that after autopsy, on the dead body, after completing autopsy on the dead body of the deceased, he recorded his findings in the post-mortem examination report, PME report, EXT1. Poster. PW5 exhibited. He identified his signature in PME report EXT3 as EXT31 and the signature of the superintendent, Deepu Civil Hospital as EXT32 and the signature of the Joint Director of Health Services, Karbi Anglong Deepu as EXT33. Poster. In the autopsy report, he recorded the following findings. Page 17. Option. A lot. Not a lot. He stated that in the PME report EXT3, he opined that the cause of death was due to head injury caused by blunt trauma, BLUNT-TRAUMA. Full stop. When PW5 was cross-examined, he stated that blunt trauma sustained by the deceased could be due to fall on hard substance or if the disease got hit against any hard substance. Poster. In common parlance, blunt trauma refers to injury of the body by forceful impact with a dull object. Full stop. With blunt force trauma, there can be internal organ injuries that are not immediately visible. Full stop. On scrutiny of the PME report, EXT3, and on a reading of the testimony of PW5, of the autopsy doctor PW5, we find that there is no it has not been reported categorically therein that the death of the deceased was a homicidal one. Though, full stop. থাকিল কি থাকিল? কি থাকিল? Accused was examined under section 313 and thereby, was provided with the opportunity to explain any circumstance any incriminating circumstance emerging from the evidence of the prosecution, emerging from the prosecution evidence. He stated that his deceased father used to fight with his mother every day. Full stop. As regards the events which occurred on the date of the incident, he stated that at around 10:30 p.m. on the date of the incident, his father in an intoxicated state, was fighting with his mother. When he requested his father not to fight with his mother, he was seized by his father with a wooden batam. On being so seized, he had to run out of the house. Run away from, he had to flee away from there. And it was after about 1 hour, he returned back to his house. There, after return, he saw that his father was lying on the floor and his mother was standing nearby. Then his mother asked him to lift his father, and he accordingly lifted him. Thereafter, both of them kept sitting near the near his father on that night, Pusta. He stated that when he lifted him, he saw injuries on the head and on the head of his father, with blood oozing out therefrom. Pusta. It was on the next, it was on in the morning, the persons in the neighborhood were informed. And thereafter, the case was lodged by his mother against him. Pusta. The accused also stated that his mother, that is the informant, was suffering from paralysis and was not had lost her speech since about 4 years. Since about last 4 years. Post of prayer. In the circumstance evidential of question. এই প্যাকেট এই প্যাকেট সারডা 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 সারদার প্যাকেট বাংলা প্যাকেট এইটো নহয় সারদা এইটো মোৰ প্ৰিন্টৰ It has clearly emerged from the above discussion that the case on hand is a case based on circumstantial evidence, as no one had testified as eyewitness of the occurrence. Full stop. It is too well settled that an accused can be held guilty, can be convicted if he is found guilty in cases of circumstance, in cases based on circumstantial evidence, provided the prosecution is found successful in proving beyond reasonable doubt the complete chain of events and circumstances pointing definitely towards the involvement of the accused as the perpetrator of the crime. Full stop. The parameters, the standards which are required to be met by the prosecution in a case based on circumstantial evidence have been delineated, have been succinctly delineated in the oft OFT quoted three judgments decision in Sarad Pedisan Sarada versus State of Maharashtra, reported in 1984 for SCC 116, in the following words. এইটো যে দিছিলে এইটো যে ফাইনেলাইজ কৰি দিলে যে এই তাৰে পেৰা 50 নালাগে ইয়াতে দিলে হ'ল ইয়াৰ পৰা দি দিলে হ'ল 152 ইয়াতে আছে হা ইয়াতে এইটোত আছে পেঞ্চিল এইটো 53 এইটো মেইন আৰু এইটো বাইবেল আৰু Anjan Kumar Sharma, same thing is said, Sarad only.
Sharad Bridgeson and regarding also that weapon, blood stain in weapon also.
We'll take that. All right, that's it. Uh, আৰু এটা পেৰা এইটো পিছত হ'ব হা। One of the aspects which assumes importance in a case based on circumstantial evidence is existence of motive. মতো গেছিলা নহয় motive.
Motive 1992 আছে।
$92.
Sakhara versus State of Madhya Pradesh।
বেছি সৰু এইটোত বেছি ভালকে নাই 9 if Hmm? From the the from the evidence laid by the prosecution, comma, we do not find emergence of any motive which can be attributed to the accused for compelling him to commit an act of murder. Full stop. That's the truth. That's the truth. In face of what did he call? In the uh, in face of the in view of the opinion of the autopsy doctor that the diseased, the cause of death of the disease was was due to the head injury caused by blunt trauma, the prosecution could have benefited by showing the wooden bottom to the autopsy doctor to obtain his opinion as to whether the head injury sustained by the deceased could have been possible by such kind of wooden bottom. Full stop. But the prosecution despite making seizure of the wooden bottom wide seizure list EXT1 EXT 1 had not only omitted to show the to not only omitted to exhibit such wooden bottom as a material exhibit, did not show the wooden bottom to the autopsy doctor. Full stop. The prosecution had even failed to produce and exhibit The wooden bottom, comma, stated to have been seized by the seizure list EXT1 during the entire course, during the trial. Full stop. If the seizure list EXT1 is looked at, it is found that when the wooden button was seized, on at 8 a.m. on 25/9/2013, there was no indication that the wooden button was a blood-stained one. At least to draw a prima facie, to draw an inference prima facie that it was used in the commission of committing the assault, comma, as alleged by the prosecution side throughout. Full stop. এই মোটিভৰ ডট যে দিছো ডটৰ পিছত লিখি থওক the accused was not attributed any kind of criminal antecedent by the prosecution witnesses, more particularly, comma, by moderator to be answered by moderator to PW2, who was the elder brother of the deceased. Full stop. In fact, comma, PW2 had pointed towards the pointed had categorically stated that the deceased used to be the aggressor and the accused used to be the recipient. You recipient be right. Bold quit. From such previous conducts of the deceased and the accused, comma, no motive can be inferred for aiding. No motive can be inferred, and absence of motive comma, in such situation, comma, becomes a missing link in the case of the prosecution. Full stop. Date kolu, lathi kolu, motive kolu, not homicidal opinion naibly kolu. It is from the explanation. From the explanation, not again. From on an evaluation of the testimony of the prosecution witnesses and the explanation vis-a-vis the explanation provided by the accused, comma, it has emerged that during the night intervening 24/9/2013 and 25/9/2013, comma, the accused was in an intoxicated state and it was a possibility that the accused playing the role of an aggressor, comma, as always, comma, entered into a quarrel with his wife and his son, comma, as projected by the accused, comma, and in the process of changing the accused received the head injury due to forceful impact on a hard object, resulting into blunt trauma.
Disease, madam.
Huh?
Disease.
Disease. Poster. When in the light of the well-settled principle that each and every incrementing circumstance must be clearly established by reliable and cleansing evidence by the prosecution and the circumstances so proved must form a chain of events from which the only irresistible conclusion about the guilt of the accused can be safely drawn, and ruling out any hypothesis any other hypothesis against the guilt, ruling out the possibility of any other hypothesis against the guilt, comma, when the facts and circumstances of the case in hand is case in hand or on hand? Case in hand are examined, comma, we are not persuaded to reach a view that the prosecution has been able to establish each and every incriminating circumstance by any reliable each and all the incriminating circumstances by reliable and cleansing evidence. And we find that there are few missing links in the chain of circumstances due to want of reliable and cleansing evidence. Full stop. Obviously, in a paragraph, suspicion, however strong, so এটা প্যারা থেকে থাকো কার্য লিখিব upon evaluation of the evidence stroke materials on record in its entirety, comma, we are of the considered view that though the evidence stroke materials on record do raise sorry, point towards points a needle of suspicion towards the accused. But the prosecution has not been successful to make the case to move from may be true. From the uh, from the from the parameter quantitative parameter which is xylem of quote unquote may be true to the from the stage of may be true to the stage of must be true. As required in law to return a finding of guilt from for a criminal charge, comma, uh, uh, more particularly, in a serious crime like murder. Full stop. Having regard to the nature of evidence led by the prosecution, as discussed herein above, we are of the considered view that it will be unsafe to sustain the judge's conviction, to sustain a conviction for a charge of murder against the accused. And as a consequence, the accused as a consequence, we find that the well-settled principle of criminal jurisprudence that if there is two High Court. Or criminal jurisprudence that if two views are possible on the evidence adduced in the case, one pointing to the guilt of the accused and other towards his innocence, the view which is favorable to the accused should be adopted. Full stop. Thus, we find that the judgment and order of conviction and sentence rendered by the learned trial court is not sustainable in law. And therefore, the instant criminal appeal succeeds. Full stop. Accordingly, by setting aside the judgment and order of the learned trial court, impugned hearing, the criminal appeal is allowed. Full stop. Para. Release in no other case. Appreciation. Ahmed. Send back the case.
Problem.
One of the conduct, Your Lordship.
Yes.
he
Anything
was
missing?
available at the place of occurrence. He was detained from his residence itself by the police.
It was
Subsequent complaint.
detained from the. We'll see. It might go in his favor.
It will go in.
He is not absconding.
Yes.
Item number 17. In item number 17, I have been informed by the informant that he has not received the paper book. So may I pay that?
1 minute, 1 minute. Let me close this, then say. One by one. 1 minute. Yes, it's possible. 7 minutes. More than summary long. Yes, good as well.
Informant has not got the paper.
Lordship.
Order to DD.
Mr. B.M. Decca.
Order to DD. Ask query. Order dictate query.
Mr. Informant is not.
No,
Yeah.
he's not even.
He informed us
This
both
is
of us.
submitted at the bar that the informant has not yet been received, yet been supplied with a copy of the paper book. Let registries furnish a copy of the paper book to Mr.
B.M. Decca.
DM.
B.M. Decca, Legal Aid Counsel. Learned Counsel appearing on behalf of the informant respondent number 2. List after. List
2 weeks.
after 2 weeks on a date to be fixed by the registrar.
Problem.
Ek minute. অলপ similarity আছে ন ৰঙা মাৰি থৈছো অলপ similarity আছে ইয়াৰ পৰা যোৱাৰ হলে চব পাহৰি যাবে মোটিভটো অলপ থাকি গ'ল হা মোটিভটো এটা
Go through if you need
2
to,
weeks.
we'll file.
Let it be in September because there's lots of holiday in August. Madam.
Oh, yes, right.
Yes.
Right. Even in September also there was one holiday. First week. 9th of September?
My lord, no,
Today is what?
today is 9. Yes,
9th of August.
9th of September? Because yes, August. 1 to 15 August. 4, okay. Or 6th of September or 9th of September, which one?
I am always available.
Ah. Mr. K. Mohammed, Learned Counsel for the petitioners. And Mr. T.J. Mohanta, Learned Senior Counsel and Standing Counsel, Guwahati High Court. Assisted by P. Sharma, Learned Counsel for the respondents are present. First up, it is submitted by the Learned Counsel for the parties that in opposition. on behalf of the respondent number 4 and 5
4 and 5.
has been filed yesterday. Full stop. And the said affidavit, counter affidavit has not yet been tagged with the case record. Full stop. Mr. Mohammed, learned counsel for the petitioner, has submitted that he has received a copy of the counter affidavit only yesterday
Yes.
and needs 3 weeks time to file
Legend.
a rejoinder
If required by him.
has submitted that he needs time
Also.
to go through the same and to file a rejoinder if necessary.
Yes.
Full stop. He has thus sought for listing of the case after 3 weeks.
Fine.
Yes.
Keep it up.
As agreed to by the learned counsel for the parties, list the case on 9/9/2024. Interim order passed earlier shall continue till the next date of this.
Keep it up.
Highly opposed.
Number 2,
My lord, actually, my lord, that is for regarding my lord temporary arrangement. My lord, in also this could sort of I file affidavit, but it is tag with that.
Okay.
No problem.
K. Mohammed, learned counsel for the petitioner, and Mr. T.J. Mohan আগৰখিনি লিখিব
Yes.
তাৰপিছত লিখিব as sought for by the learned counsel for the parties, list the case on
Fine.
9/9.
Ninth.
Keep it up.